Hi there, I'm Jenna Leyton Jones, the Vice President of Legislation for San Diego SHRM, and today I'm bringing you your quarterly employment law update. Let's start by taking a look at some California legislation. Changes to the regulations regarding heat illness prevention went into effect on May 1, 2015. Employers who have employees working outdoors should familiarize themselves with the new regulations and update their heat illness prevention plans and training. The amended regulations apply to outdoor workers and include the following. Water must be pure, suitably cool, and provided free to outdoor workers. It must be located as close as practicable to where employees are working. When temperatures exceed 80 degrees Fahrenheit, shade is required for all workers on break and for all those who take their meal periods on site. For climates cooler than 80 degrees, shade must still be made available upon request. Workers who take cool-down periods must be monitored and asked if they are experiencing heat illness symptoms. Employers must ensure that supervisors and workers are adequately trained to recognize and react to heat illness signs and how to contact emergency medical services. Any workers who display or report symptoms of heat illness must not be left alone or sent home without being offered on-site first aid or emergency medical services. Any worker newly assigned to a high heat area must be observed by a supervisor or designee during the first 14 days of employment. Training must be provided for all outdoor workers before starting any work involving heat illness risk. The training must be presented in a language that employees understand and must be documented. Now let's switch gears and take a look at some of the recent judicial decisions that may affect your business. In Neely v. City of Santa Monica, a California Court of Appeal affirmed the trial court's grant of summary judgment for an employer in a case involving claims for disability discrimination, failure to provide reasonable accommodation, failure to engage in their interactive process, and retaliation. Tony Neely worked for the City of Santa Monica as a solid waste equipment operator. After injuring his knee at work, Neely took multiple leaves of absence. The city reassigned Neely to a groundskeeper position. After a second injury, Neely returned to light-duty work with restrictions. Neely requested that he be placed in an equipment operator position. The city conducted several meetings with Neely and his attorney and hired a disability consultant to determine whether Neely could perform the essential functions of the equipment operator job. The city concluded that Neely's restrictions inhibited him from performing the job. The city contemplated reassigning Neely to a vacant position. However, Neely was not selected for reassignment because he did not possess the minimum qualifications for the job. After exploring these options, the city concluded that it could not accommodate Neely. The city thereafter extended Neely's leave of absence while it applied for disability retirement for him, effectively ending his employment. The appellate court found that the city lawfully terminated Neely's employment. Notably, the court rejected Neely's argument that the city could have restructured his former position so that he would not have to kneel or lift heavy objects. The court concluded that such modification was not reasonable because kneeling and lifting heavy objects were essential functions of the job, and employers need not eliminate essential functions in considering accommodations. The court additionally rejected the proposition that the city could have reassigned Neely because he was not qualified for any vacant positions available at the time of his request for accommodation. The court confirmed that the law does not require employers to provide an indefinite leave of absence so as to allow for possible future vacancies. This case serves as an important reminder that when a disabled employee requests a reasonable accommodation, the employer should thoroughly evaluate the essential functions of the employee's job and regularly communicate with the employee throughout the interactive process. Employment separation should be the last resort and an option only contemplated after all accommodation and reassignment possibilities have been exhausted. In Dixon v. Burke Williams, a California Court of Appeal held that an employer cannot be held liable for failing to prevent harassment and discrimination under the Fair Employment and Housing Act when an employee cannot establish that illegal harassment or discrimination occurred. Dominiqua Dixon filed a lawsuit against her former employer, Burke Williams, alleging a series of claims under the FEHA arising out of her work as a massage therapist. Dixon specifically alleged that she was subjected to sexual harassment and discrimination by customers, and that Burke Williams failed to take adequate steps to prevent that conduct. At trial, the court instructed the jury that with regard to Dixon's claim for harassment, she was required to establish both that she had been harassed based on sex and that the harassment was, quote, severe or pervasive. However, the trial court instructed the jury that with respect to Dixon's claim for failure to prevent harassment or discrimination, Dixon's burden was simply to establish that she had been subjected to harassment or discrimination based on sex. In other words, she was not required to prove that such conduct was severe or pervasive. The jury concluded that harassment had occurred, but was not severe or pervasive. Relying on the trial court's instructions, the jury found for Dixon on her claim for failure to prevent harassment, even though it found that no liability existed for the underlying claim for harassment. Burke Williams appealed. The appellate court reversed the jury's conclusion, holding that liability for failure to prevent harassment cannot exist where no actionable harassment occurred. As the appellate court explained, it would be improper to provide a legal remedy for failure to prevent actions that were not unlawful. Moreover, although the approved jury instructions for the failure to prevent harassment claim did not explicitly state that the alleged harassment needed to be severe or pervasive, they required that the jury be instructed on the elements of harassment, which included the severe or pervasive language. The appellate court extended the ruling to hold that an employer cannot be held liable for failing to prevent discrimination where the employee cannot establish liability on the underlying discrimination claim. This decision is a positive development for employers as it affirms a strong defense to a claim for failure to prevent harassment or discrimination. However, the decision also serves as a reminder that employers have an affirmative duty to prevent harassment and discrimination in the workplace. Failure to meet this duty can create an independent cause of action for employees. It is therefore imperative that employers implement and enforce zero-tolerance harassment and discrimination policies. In Young v. United Parcel Service, the U.S. Supreme Court found that the Fourth Circuit Court of Appeals improperly interpreted the Pregnancy Discrimination Act. Peggy Young worked as a part-time driver for UPS. Her duties included picking up and delivery of packages. UPS required drivers to be able to lift packages weighing up to 70 pounds and up to 150 pounds with assistance. After suffering several miscarriages, Young became pregnant. Her doctor advised her that she should not lift more than 20 pounds during the first 20 weeks of her pregnancy and not more than 10 pounds thereafter. UPS told Young she could not work while under the lifting restriction, and Young stayed home without pay for most of her pregnancy, losing her health care benefits as a result. Young filed a lawsuit in federal court under the Pregnancy Discrimination Act, alleging that UPS failed to accommodate her pregnancy-related lifting restriction. The Act states that women affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all employment-related purposes as other persons not so affected but similar in their ability or inability to work. Young argued that UPS accommodated other drivers who were similar in their inability to work but failed to accommodate pregnant employees. Young presented evidence that UPS accommodated drivers who had become disabled on the job, drivers who lost their Department of Transportation certifications, and employees who suffered disabilities covered by the Americans with Disabilities Act. UPS argued that Young did not fall within any of these categories. UPS further argued that it did not discriminate against Young on the basis of pregnancy, but rather treated her the same way it treated all other relevant persons. The trial court granted summary judgment in favor of UPS. The Fourth Circuit Appellate Court affirmed. The appellate court reasoned that Young was not similar to the other groups of employees granted accommodations by UPS. Young was not disabled under the ADA, and her lifting restriction was temporary and did not significantly restrict her from performing major life activities. The appellate court opined that UPS crafted a pregnancy-blind policy, and that was at least facially neutral and a legitimate business practice, and not evidence of UPS's discriminatory animus toward pregnant workers. The U.S. Supreme Court, however, determined that the lower courts had misinterpreted the act and that a jury could find that UPS treated pregnant employees differently than other employees similar in their inability to work. A pregnant worker can prove a disparate treatment discrimination claim with indirect evidence. A plaintiff's case can survive summary judgment and proceed to trial where there is evidence that the employer's policies impose a significant burden that gives rise to an inference of discrimination. For example, a plaintiff may offer evidence that the employer accommodates a large percentage of non-pregnant workers while failing to accommodate a large percentage of pregnant workers. In this case, the fact that UPS had multiple policies that accommodated non-pregnant employees with lifting restrictions suggests that its reasons for failing to accommodate pregnant employees with lifting restrictions were not sufficiently strong, and a jury could find an inference of discrimination. Employers should examine their policies regarding accommodation requests to ensure that they are compliant with this interpretation of the Act. Employers should remember, however, that every request for accommodation is unique and should evaluate each request on a case-by-case basis. In Williams v. Chino Valley Independent Fire District, the California Supreme Court held that a prevailing defendant in a Fair Employment and Housing Act case can only recover costs of suit where the plaintiff's action was objectively groundless. Loring Williams worked as a firefighter for Chino Valley Independent Fire District. Williams sued Chino Valley, alleging disability discrimination and violation of the FEHA. The trial court granted summary judgment in Chino Valley's favor and awarded it costs totaling $5,368. The Court of Appeal affirmed, holding that the prevailing party was entitled to court costs as a matter of right pursuant to Code of Civil Procedure, Section 1032B. However, a defendant should only be awarded attorney's fees if the plaintiff's suit was baseless and unfounded. On appeal, the California Supreme Court held that a defendant prevailing in a FEHA action is entitled to recover its ordinary costs only in the discretion of the trial court. Section 1032B guarantees that prevailing defendants are entitled as a matter of right to recover the costs expended in litigation, except as otherwise expressly provided by statute. The court reasoned that Section 12965B of the Government Code expressly excerpts parties in a FEHA action from this entitlement. The FEHA statute states that costs are awarded in the discretion of the trial judge. In civil actions brought under that section, the court, in its discretion, may award to the prevailing party reasonable attorney's fees and costs. Thus, the trial court has discretion in deciding whether to award ordinary costs to a prevailing defendant in a FEHA action. In holding that a prevailing defendant should only recover its costs and attorney's fees if the plaintiff's action was objectively groundless, the California court opined that plaintiffs should not be forced to bear such a high risk in order to vindicate their statutory right against workplace discrimination. Because even ordinary litigation fees can be substantial, the possibility of their assessment could significantly chill the vindication of employees' civil rights. Pursuant to this ruling, a prevailing plaintiff will generally be able to recover his or her costs and attorney's fees, while a prevailing defendant likely will not be awarded costs or attorney's fees unless the court determines that the plaintiff's claims were frivolous. The cases I just mentioned are just a sampling of recent judicial decisions that affect California's employers. For more information on these and other hot legal topics, check out SDSHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join SDSHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please contact me at jleyton@petitcone.com. That's all for this quarter's legal update. Thanks again for tuning in.